Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration and Q&A session. You can call the numbers displayed on the screen and ask any question related to immigration, and attorney will be glad to answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. Hi Prashanthi garu, how are you doing?
Hello, Ranjit, how are you?
I'm good. A lot of things happened in the last week. Let's start with the latest updates. I believe there are a few updates before the Trump admin left. So we just want to know what all those updates and what are the chances of those becoming, implemented in the current administration. Will they still pursue it, or are they going to go, down? So please explain what's going to happen and what are these regulations.
Well, there are many regulations, so I'm not quite sure which ones you're asking about. They're like
there are three regulations
that pass.
Yeah, especially the last.
But I think the ones that concern legal immigration and H-1Bs is maybe what I can focus on. And there are three of those. So the first one is, this basically is something of interest to people who are on H-1 or people who have IT companies. So the first one is basically the registration process. So we know that the H-1B cap season will start on March 1, right? So, and we know that there's a new process since last year. It's, first a registration. So anyone who's interested will first register, and then they will, they're supposed to have a random lottery. Earlier, everybody would just file and they would pick based on a random lottery. This year, same as last year, they're going to first do a pre-registration. So basically, you'll just put in your name and some information, and based on that registration, they will pick. So you don't have to file the entire petition, which is helpful because it's a waste of all the money and resources, time that go into filing a petition if it's not finally picked in the cap. So what they're saying, the new regulation that is published in the Federal Register and will be effective on March 7th, says that the lottery system will no longer be a random lottery that is computerized, but it will be based on wage levels. So, for example, if you're using a wage level of 4, then it's likely that your case will be picked. If you're using wage level 1, then it's most unlikely that your case will be picked. So they're going to do the lottery based on the wage levels. So they will start with wage level 4, then they will go to wage level 3, then 2, then 1. One interesting point about this is that, for example, in Kentucky, maybe wage level 4 is equivalent to wage level 1 in California or in some other big state. So there's no parity even there. So they will just blindly go based on the wage levels. They're not actually looking at the numbers in the salary. They're just going based on wage levels. So the disparity is not just geography here, because obviously then only people from Kentucky will get their H1s picked in the lottery and not people from New York or San Francisco or some other big city. So the disparity with reference to geography, and not just that, disparity with just the whole system that they're choosing, just to presume that someone who has a wage level 4 is somehow more important than someone who has a wage level 2. To give you an example, say a software engineer has a wage level 4, but a physicist or a scientist or even a Nobel Prize laureate has wage level 2, the software engineer is going to be picked, even though he is not exemplary in his field, or he is just a regular average Joe. He's going to be picked, or she's going to be picked over your physicist or scientist or doctor, or so basing wage level and saying that based on wage level we think you're more important, or that's why we'll pick you, is itself complete nonsense. So As to what will happen with this published rule, it is to be implemented. It's a final rule. There is notice period is over already. But the Biden administration said that automatically they were, for all regulations that have not yet been come into force, that are not yet been implemented, they are giving us 60 days. They are postponing it by 60 days. And then they will look into it further and decide what to do with it. So if you postpone that by 60 days, then it'll go into May. They can postpone it further as well, or they can rescind it, depending on the comments that they get. So we have to wait and see whether this is actually set to be implemented, which it is set to be implemented, but whether it'll actually be implemented or not. The other thing to keep in mind is even if it's implemented, I'm sure the next day there will be a court case. There will be several challenges in court. And I don't think it stands a chance because they're just basically changing the law. And a regulation is not a law. A regulation is supposed to interpret the law, not change the law. So there is no law which says that, you can have the lottery system based on wage levels. So they have to go back to Congress if they actually want to change that. And they haven't done that. So, based on that, I think hopefully courts will throw it out. So that is one very, very important change that is forthcoming. The second change is with reference to wage levels. Now, and that has also been published. And there is a date that is going to be implemented. That's in March. So the wage levels also is a little scary because they've brought back, everything is back to status quo. If you remember in October, they did an interim final regulation and the wage levels actually changed and level 1 became, equivalent to level 3. So it's the same thing again, back to square one. They were able to, the courts threw out that interim final regulation based on procedure. So they said that they didn't follow the actual comments and publication period. And based on that, the courts invalidated that law, that regulation. But now they have published it again and they're now doing it procedurally correct. So this time, if there is, and I'm sure there will be, challenge in court, they'll have to actually look into the merits of whether such changes in wage level is, based on the Immigration and Nationality Act or it violates the act. So they'll actually be looking into the merits and not just the procedure. So we have to see whether that gets implemented. Also, since the same thing, the regulation is stayed by 60 days. So, it's up to the administration to decide whether they will move forward with it or not. So same as, DOL wages or the registration, both are in the same book. We have to wait and see what the new administration will do. And the third and the most, I think, damaging regulation is, for at least for IT staffing companies, is strengthening of H-1B regulation that has not yet been published, but it can be published anytime. It can be published by the new administration as well. But it's proposed regulation, whereby they say that if you're a staffing company and if your employee is working for a third party, for an end client, and if you're not controlling, it's again back to the right to control. And if you don't control the work of the employee, and those 9 points that that we've had to deal with for years with reference to right to control. So that has come back, and they're saying that if you don't meet those requirements of an employer, then not only do you have to file the LCA and the H1, but the end client also has to file the entire H1B petition. In addition to that regulation, preempting the regulation, the Department of Labor and the Wage Hour Division, WHS, both have published memos stating, and this is not a regulation, this is a memo that they have published. Remember, every agency is different and can operate independent of one another. So the DOL WHS has published a memo simply saying that they have changed the interpretation of the law. They're not saying that the law has changed, but they're simply saying that the interpretation that they used to give earlier has changed. And now they're interpreting it to be that if the employer is working at an inclined place, then the end client also has to file the LCA and H1. Of course, they based their interpretation or change in interpretation on the regulation that is supposed to be published but not yet published. So if that never gets published, then it's unlikely that the memo from DOL will be implemented. Most probably they will rescind that memo by issuing another press release or another memo. So we have to wait and see what happens with that. So the three agencies involved there, the DHS, Department of Labor, and the Wage and Hour Division. So that's the third and I think most damaging regulation that we have to watch out for, because in all three, pretty much the purpose seems to be to eliminate lower level employees or to eliminate employees that are, have less number of years of experience, and also to pretty much eliminate the whole staffing company model by saying that clients have to file LCAs and H1s, because we know no client will file an LCA and a H1. And if they had to, then they would just do it themselves. They would put them on the payroll and file their own H1 and LCAs. So there's no role for the staffing companies to play anymore. Now, if this gets implemented, the only recourse we have is to show that the right to control is still with the staffing company and not with the end client. So that we've been doing that successfully in many of our, the right to control cases, RFEs that we've had in the past, and which went away, of course, because of the ITServe lawsuit, which they won. But now it's come back in a different way. So we'll have to again prove the same thing, that, the staffing company has the right to control, not the end client, and therefore the end client doesn't have to file the LC and H1. So that's the only way to overcome, I think, that particular regulation if it does get implemented. So these are three things that we have to wait and watch and see what happens. The Biden administration, they're expected obviously to be more lenient, but they have a lot on their plate, and we don't exactly know where they stand with reference to high-skilled workers and H1s. So let's wait and see what happens. I'm hoping that if the Biden administration continues with trying to implement these regulations, then the courts are our only recourse, and I hope the courts will then overturn them.
Okay, let's assume this H1B registration thing, it's taking time and to go to the court, or it's, too late. So do you think it will still be implemented this year? Because I believe last year, I think before in 2018, I believe the registration process change was almost done during the period, but they started implementing it the next year because the system is not ready, because they have to come up with a new system for this registration based on the wage levels or whatever. So do you think still it will be done this year, even let's say if it's implemented?
So it's already implemented. That one is already implemented. It's already in the public register, and they've said that it will start from March 7th. The only saving grace we have is that the Biden administration has said they'll put a 60-day moratorium on all regulations that have not yet started being put into action. So, right, the notice and comment period is all over. It is a final regulation. It's there, but the Biden administration can always rescind it because it has not yet. The implementation has not yet started. It's starting from March 7th, 60 days. So let's wait and see what they do. But they have said that they will automatically extend by 60 days all pending regulations. So I hope that at least for this year's registration period, it won't be implemented.
Okay, got it. The new administration has released a fact sheet saying that they want a comprehensive, do a comprehensive immigration, most of which is being taken from the 2013 bill. It looks like that. Could you please elaborate, key points in that and how it's going to help the high-skilled immigrants, and what changes, if implemented, will be done, and how long it's going to take and all?
So, so this is a bill that President Biden has said he will present to the Congress on the first day. So, and we only have some outlines. We don't have the details of the bill. We will have that, I guess, once it's published. But the bill, remember, is actually quite different from the previous comprehensive immigration reform bill, because there was a lot of emphasis on restriction and security and border control, and a lot of restriction on H-1B in the comprehensive immigration reform bill. So there's not that much, it's not as restrictive. Actually, it's much more liberal than the comprehensive immigration reform bill that they tried to pass earlier. Basically here, earlier in that bill, it was like giving a pound of flesh, because they were giving amnesty. They tried to put in as much, the Republicans tried to put in as much restrictionist language as possible so that the bill could be passed. But remember, this bill is only being sent to the Congress. It's up to the Congress. They might modify it, they might make changes, they might decide even not to let it pass. But for it to be passed, remember that it might be passed in the House because they have a complete majority. But in the Senate, they only have a simple majority, so they would need 10 more Republicans to pass this bill in the Senate as well. And that's, I think, the challenge. And when that happens, I think a lot of the Republicans will want other clauses to be put in here, because everybody wants something from the immigration reform bill. But as it stands, and based on the knowledge that we have and the fact sheet, the main purpose of the bill is to create a roadmap to citizenship, basically. So it's like an amnesty program, which Democrats have been trying to implement, and even some Republicans have been trying to implement for years, for decades, since the Life Act came in 2000, passed by Bill Clinton. Since then they've been trying to do another amnesty related act. And the reason they're doing this is to ensure that people who are out of status can get back into status and get out of the shadows and get some kind of formal status, so that they might, live with security in the society. Because now, if you're illegal, you're scared to go to the hospital, you're scared to, in some states, you're scared to go to the police if there's some issue. Domestic violence goes unreported. They are often exploited, the illegal aliens, by their employers, because they're not allowed to work. They can't pay taxes. So there's so much of tax revenue that is being lost, because a lot of them are working and not paying taxes. And most importantly, you cannot deport the several million illegal immigrants that are in this country. So what do you do with them? There has to be a solution. It's important to secure the borders and not allow new people to come in and become illegal. But what do you do with the people that are already there? So that's why I think this program is inevitable almost, because there has to be some way of dealing with these millions of illegal aliens that are in the US. So the plan that they've come up with is that they will get a green card in 5 years, provided they meet. They'll be first given a temporary status whereby they can work and pay taxes. We don't know if they can travel. Most probably they can. Maybe they'll be given advance parole. And in those 5 years, if they pay taxes, they have a job, they don't have a criminal record, and they go through all these security checks and background checks, they will be able to get a green card after 5 years. And then in 3 years, citizenship, usually if it's employment based, after you get your green card, you have to wait for 5 years to become a citizen. unless it's you get your green card through family, through, for example, marriage based, then you get it in 3 years. So here he's cutting short the period for citizenship. He's making it 3 years. So after you get your green card, after you get this temporary status, after 5 years you get your green card if you meet the requirements, and after 3 years you can apply for citizenship. So that's the most important element, I think, of this bill. Of course, he's providing a way for dreamers, people with TPS, immigrant farm workers to be immediately eligible for a green card. So dreamers don't have to wait for 5 years. They will be able to file a green card immediately, as long as they meet the background checks and English language, etc., etc. One important key point for this to qualify is that you should have been in the country as of January 1, 2021. So new people, so this avoids influx of, as Trump says, caravans, people trying to get into the country so that they can get legal status. That won't happen. So if you try to come into the country now and you become illegal, or you come in illegally, you don't get that benefit. You only get it if you were already in the country as of January 1, 2021. There are some exceptions for family unity if people were in the country on or after January 20th, 2017, and they were here for at least 3 years, and then they were deported and they have immediate family in the US, then I think they're carved out exceptions for those people. So even if they are not in the country, they can still get take the benefit of this amnesty. The other thing is they're focusing on keeping families together, not separating families from one another. And in order to do that, they are clearing the backlog of the family-based visas. So family-based immigrant petition, as you know, everything is backlogged, except for the immediate relatives where there's no backlog because there's no visa number availability required for the immediate family. Immediate family is basically parents, children, and spouses of US citizens. So other than that category, all the other categories are backlogged, except in this month and last month, we've seen there's been movement for spouses of permanent residents, etc. But in general, historically, they're very well behind. You have to wait for several years if you're a permanent resident to bring your spouse and etc. So what they're doing is recapturing the unused visa numbers from previous years. That's part of the bill. And that automatically eliminates the waiting time because they should be able to clear most of the backlog with that if they're able to do that. They're also increasing the per country visa cap. So they're increasing the number of visas. That's a proposal. And this is a better way of doing it rather than, some criticize the previous way that the bill, there was a previous bill, right? High skilled workers bill. And the criticism was that they should actually increase the visa immigrant numbers instead of removing country caps. So that's what they're trying to do here. They're increasing the visa caps for family-based. And most importantly, there's a 3 to 10 year bar right now, which was instituted several years ago, which basically says that if you've been out of status, that means your I-94 is expired and you remain in the country for more than 6 months, then you're barred from coming into the country for a period of 3 years. And if you are out of status for more than a year or 6 months to more than a year, then there's a 10-year bar against you. So they are removing that. And that has been a contentious law, right, since its implementation. So, I'm not surprised that they're seeking to eliminate that 3 to 10 year bar period because it has kept families apart. That's the main reason why families have been kept apart, this 3 to 10 year bar. So unless they qualify for a waiver, they can, 10 years is a long time to be separated from your family. Also, they've included additional families, partnerships that can be that can file for green cards, LGBTQ, etc. And also they've implemented some new protections for orphans, widows, children, and Filipino veterans who fought in World War II. Also, the bill allows immigrants with approved family sponsorship petitions to join families in the United States on a temporary basis. This is important, while their green cards become available. So what they're saying is, if you have to wait because there are backlogs with your visa numbers and that has not been taken care of even after adding the visa numbers or recapturing unused visas, and you can come in on a temporary basis while you're waiting for your visa number to become available. This is great, actually. So this is to avoid family separation. So they come in on some kind of a temporary status, maybe a temporary green card status or a temporary work status, and then they can stay with their family and be in the United States, pay taxes, while they're waiting for their green card to be approved. So I think that's really great. The other one is, excuse me. The certain things that they've implemented to grow our economy. This is basically legal immigration. The bill clears employment-based visa backlogs. Same, I was talking about family visa backlogs. This is now employment-based visa backlogs. And they're saying that you can recapture, again, the unused visa numbers, and this way reduce the wait times and eliminates per country visa caps. That would be great if that passes. So it's much more comprehensive than the previous bill that they tried to pass, because they're talking about eliminating the per country visa caps and increasing the visas and recapturing unused visa numbers. So I think then this way no one will, earlier there was concern that if one country benefits, then another country will be backlogged. I think now they shouldn't have that concern because most countries will become current. And also it makes it easier for the graduates who've done their master's degree here, especially if it's in a STEM field, to stay in the United States, and also eliminates unnecessary hurdles for employment-based green cards. So just makes it easier overall. Also, the bill provides dependents of H-1B visa holders work authorization, which is great, right? So because the H-4 EADs have been contentious, and as you know, there's a regulation that is pending, which will, if it is published, will revoke that. There is a lawsuit that is pending. So this finally has to be put to rest, and this can only be done via legislation. That's what they seek to do here. Another important, very, very important part is aging out problem that we have, right? So it's taking, if it takes 10, 15 years for anyone to get their green card, unless their children are born here, they will age out, because a child will age out unless they are under 21 years of age, which means that they will not be able to file a green card with their parents. And not only that, they will most probably become out of status because they will be no longer be dependents. So they'll have to find their own status, change to an F1, and then go through the entire process and wait another 20 years like their parents waited for the green card. So that's completely unfair. And so they're trying to prevent that aging out. And how they're going to do it, we don't know, but most probably they'll freeze the age, or they'll create some kind of a temporary 485 status. They'll allow them to file even before these numbers become available, and they'll create a new law under CSPA, which says that as long as you file, even if your dates are not current, even if you do it based on dates for filing, your age can still be frozen. Also, so the number of green cards, so they're saying increase number of green cards. So this will, they're saying it should be flexible. So depending on what the economy is, they will either retract the number of green cards available, or maybe increase the number of green cards. It should be flexible and it shouldn't be rigid, which makes sense because, the situation is always not the same. Sometimes there is need for, new fresh blood, and sometimes maybe there is need to close the gates a little bit. So DHS will be given the authority to decide, and I hope they use that authority responsibly, but they will be given the authority to decide, the number of visas, green card numbers available in any given year. Also, now they also have to improve, obviously, the verification process for the H1. So they'll have to bring in some kind of additional security measures on the H1B, and also prevent exploitation of H1B employees. So, as you know, because this H1B process is really report their employers, even though they're not getting paid, because they are out of status and they're worried that DOL will take some action or USCIS will take action against them. So that is worrisome for them. So they're saying that such people will be given additional, they will be allowed to file for a U visa. So a U visa is a way of getting a green card. If you file against a criminal complaint against somebody, and if you are willing to act as a witness in the case, that's a U visa. You get an automatic status, which is a U visa status. It's a non-immigrant status, but it gives you status. So they're going to extend. Usually these U visa status is given for domestic abuse, domestic violence cases, but they're going to extend that to perhaps, H1B holders who have, lost their.
Yeah, we were talking about, the U visa thing.
Okay, so what I was saying is that if they're trying to prevent exploitation of H1B workers, so presently, if you complain to DOL, but you're out of status yourself because you're not getting paid, though it's no fault of your own, DOL or USCIS can take action against you. So they're trying to prevent that by creating a new, by giving the U visa benefit to the H1B holders if they complain against their employer in a criminal case. A U visa already exists. It's an existing visa usually used for domestic violence or people who are witnesses in a crime and help the police, by standing witness. So they're going to extend that to the H visa scenario as well. So in addition to that, previously in the Comprehensive Immigration Reform Bill, there was a lot of border control, border security, a lot of money that was promised to building the wall, increasing the number of officers, and improving security that way. But Democrats have always been against building a wall, and they thought that it was wasteful to do so. Instead, what they're proposing in this bill is to improve security through technology by funding improved technology so that people crossing the border can be checked, vehicles crossing the border can be checked. And that way, rather than including, and also, drug trade can be prevented. So they're trying to strategize it better rather than just building a wall or a fence, trying to do this through technology so that they've allocated some amount of money to do that and improve, the border. Also, there's been a lot of abuse in the past. And a lot of people who live by the border communities have always complained about this. And what is happening is the ICE or, other people in charge of border security have exploited people who have, who are crossing illegally, who are close to the borders by unnecessarily, even when they are in status, harassing them if they come too close to the border, or arresting them, or in cases where people have illegally entered, instead of following the law, there's been violence committed against them. There's been rape. There's been a lot of issues with border patrol. Sometimes they've been shot when they didn't need to be. So this bill directs the government to basically look into that practice and to prevent, that this kind of this from happening. So the other thing is, of course, crackdown on criminal organizations. So we're talking about the smugglers. So they are putting in some effort and money into cracking down on illegal immigration, especially what they're trying to do, rather than target the people who are being smuggled, target the smugglers, the gangs that are often take thousands of dollars from these poor people, and they put them in a very dangerous situation. There have been instances where they've put them without food, water, and even air in closed containers or in a closed van, and they have found that people have died because of that. So they transport them, in an unsafe kind of way. So they're trying to prevent those smugglers from operating in the US. Also, the way to stop illegal immigration or people seeking asylum and seeking refugee status, mainly this is from South America, right? From the South American countries, from El Salvador, Guatemala, Honduras. So they want to try and look at the root of the problem as to why they're, in fact, embarking on these dangerous journeys from their country on foot, by foot most of the time, to the US border, and with children and infants, and trying to establish, number one, put in money into those countries so that crime can be prevented there, so that and the economic situation can be improved in those countries, so that they don't feel a need to come to a different country or to immigrate to a different country, and also for them to be able to process as refugees. By staying in their own country, they should be able to request refugee status to the US, so that they don't have to embark on that dangerous journey and come to the border. They can do it in their own country. So that they're trying to formulate a plan and put in money into that program. So I think that's a great program to kind of stem the problem from the root itself, so that it doesn't happen. Of course, improve the immigration courts and protect vulnerable individuals. The Trump administration has really eroded the independence of the immigration court system. So they are trying to bring that back and restore some fairness and balance to the immigration system by providing judges with the discretion to review cases and grant relief, independently. So they're giving back the judges some of the powers that they should have. Also support asylum seekers and other vulnerable populations. The bill eliminates the 1-year filing deadline for asylum claims. This is great because previously, as per the present law, you have to apply for asylum within 1 year of your entry into the country. If you do not, then you have to show that there were some country conditions that changed, which are making you apply now, but you didn't apply before. Now, there could be various reasons why a person doesn't apply for asylum within the 1 year. Financial reason could be the biggest one, lack of resources, lack of knowing how to do it. And if you're traumatized, you're coming from a country and you've been politically persecuted, then it takes you time to get back onto your feet and to be able to file an asylum application. So I'm glad that they're proposing to remove that 1 year deadline for filing asylum. And we talked earlier about the U visa, so providing some increased protection to the U visa, to VAWA. VAWA is basically Violence Against Women's Act. And raising the cap. The U visa is only 10,000 numbers allowed. They want to raise it to 30,000. So these are some of the elements in the bill. We don't know what will actually be passed and what additional elements will be added or modified. So we have to wait and see. But it's definitely exciting that something is being proposed, but it's too soon to expect anything. And I think it's best not to get our hopes up too soon, because this has happened in the past and the bills have never been passed. But I think this now is the time that it's most likely to happen, because there's a majority in the House, and we have at least a simple majority in the Senate, and we need only 10 Republicans, and I'm hoping those 10 Republicans can be convinced to pass the bill. So I think it's the best time for any comprehensive immigration reform bill to be passed.
Yeah, it's high time. So yeah, there are what about the presidential proclamations that were already in place during the last administration? Is there a chance or any hope that the current administration going to rescind them? And a lot of people are stuck out of country, especially high skilled as well as the family based ones planning to come. So do you think any relief to them down the line?
So those presidential proclamations have been extended, as you know, till March 2021, March 31st, 2021. The 10014, which was that family-based presidential proclamation, and 10052, which suspended the entry of non-immigrants into the country, both have been extended until March 31, 2020, which means that they'll automatically be ineffective unless the present administration extends them beyond March 31st. And I doubt that they will be extended. I don't see any. So the good thing is that the Biden administration has to actually take an affirmative action and extend it. If they don't do anything, then they will not be extended. So it's more likely than not that they will not do anything rather than extend it. But one thing to know is that 2 executive orders are passed today, or likely to be passed. One is they have removed the ban on travel ban on Muslim countries, and also they have also the DACA thing also, in the form of an executive order. They said they will reinstate DACA. But they also have said in a press release that they will not repeal the travel ban that's based on COVID. So CDC has placed some travel bans on the northern and southern boundary, and also some countries, European countries. So they have said they will not repeal the travel ban based on the CDC guidelines, because that makes sense. That's not politically motivated. It's based on the health and wellness of people in the United States. So that they will not repeal, but they have most probably already have repealed the Muslim ban, or will do that with immediate effect. And as I said, the other 2 bans with reference to the non-immigrant and the family-based immigration will automatically become ineffective as of March 31st. So I'm hoping that it will not affect this cap season. That's my hope.
Yeah, hopefully. And the other thing is, I believe starting January 26th, anyone coming into the US must go to the COVID test. That's another way. Probably they want to, make sure everyone is safe.
Which is high time, right, Ranjit? They should have done that a long time ago. Other countries are doing it.
Yes, I believe if you have to go to India, for example, from US, you have to take a COVID test within last, I believe, 2 or 3 days.
Right, India, Pakistan, most of South Asian countries, they're all doing
I think they just started doing that. So yeah, other important topic that's a need of the hour is the comprehensive immigration. So instead of increasing the number of green cards, which is mostly opposed by Republicans, the current administration tactically wants to reuse or recapture the unused green cards, which are, I believe, about 220,000 of them. So, how do you think this is going to work out for the current, people in black log, as well as how not counting derivatives, I believe, will significantly almost double the green cards. So, how do you think this will help, and what are the chances of getting them passed with in the given circumstances? What do you think is going to happen?
So for the family based, I think they have said that they will actually increase the number of green cards per country. Employment based, it's not clear, but that's more controversial, as you said. But even if they use the unused visa numbers, and if they use only one number per family, it could even quadruple the number of green cards, because if you're a family of 4, then 4 people are using 4 different visa numbers. And it's likely that even, main thing is India and China, right? And mostly India, EB2 and EB3 is what we're worried about. So there's a likelihood of it becoming current, hopefully, or very close to current, if that happens. And with reference to whether the bill will pass or not, that is really time will tell. I don't think it's going to pass in its present form, that's for sure, because a lot of Republicans that supported the comprehensive immigration reform are not in office anymore. That's one problem. And the other is this bill is much more liberal and more democratic oriented than the previous comprehensive immigration reform bill. So there's not enough restrictions in here, and I think the Republicans will want to see some more restrictions before they actually agree to pass the bill. But the good thing is we need 10. That's the golden number, the magic number. And I'm hoping that they will be able to find 10 Republicans in the Senate who will agree to pass it, or maybe they will pass it on certain conditions. So it's likely that you will see the same thing that happens always, that the House will pass a certain version, the Senate will pass a certain version, and then they will have to reconcile it. But since it's being done early on in the Biden administration, this is great. He's not waiting for his first term or first year or second year to do it, like Obama did. So we have a lot of time to work on it before it expires, and before the Democrats lose majority, they have time to actually work on it. So this is a good thing, I think.
Yeah, another key thing that's good for a lot of people is people with doctoral degrees. Most of EB1s will not be counted against green cards probably, and that would add some more visa numbers, and hopefully, let's assume.
Right. They've also said, Ranjit, that graduate degrees, so not just PhD, but also master's STEM degree holders, they haven't said what relief, but they have said that they're going to make it easier for them to get green cards. So maybe they will remove them also from hopefully. If they do, then it's a bonanza that opens up, because most of the numbers are being used by them, right? By the STEM EB2.
Yeah, I think 20,000 a year H1B quota goes to them. So
right. So if they remove them from the equation, then really we are looking at a current, all categories becoming current.
Well, apart from this, one other thing is the COVID stimulus bill that Biden's administration is proposing also has green cards for doctors and healthcare workers. So that's another thing that we have to keep in mind. If that's going to pass, there are more chances, because now we know that a lot of healthcare workers are doing a lot, risking their lives. So if that happens, that would add another 40,000-50,000 to the pool.
Yeah. And most probably to EB2, where it's most needed for doctors, because they qualify for EB2. So that'll definitely add, because that'll be removed from the pool. Yes, you're right.
Yeah. Okay. Going back to one question that has been asked a lot of times, I would like the viewers to know about it. So a lot of people now have few people already got their EADs and advanced paroles on the 485 adjustment of status. Now people are wondering, what happens if they leave the country and enter on advanced parole? Will they have their H1B intact? Do they have to do something? What happens to their dependents? So can you please explain what happens exactly when someone enters the US on the advanced parole? Will they still have their H1B like that? Or their H1B is gone and dependents will not be able to use the H4 or H4 EAD?
So if they travel on advanced parole and if they're on a H1, they are able to come back to the US and continue to be on a H1. That's an exception that they have from the general rule. So if you're on a H1 and you are not using your H1B visa to come back in, but you're using advanced parole, it's fine. You can still continue to work on a H1 and use your H1 and your same thing with the dependents, the H4s, and they would then continue to use their H4 visa. They can continue to use their H4 EADs. Advanced parole will just be used as a way to travel back into the country, but doesn't actually change your status upon arrival. It continues to be, 485 pending and H1. But as opposed to that, if you use your EAD to work, then your H1 is out the window. You have changed to an EAD status, which is you're just on adjustment of status. That's your only status pending 485. You have lost your H1 status, and same thing with H4. If they use their EADs based on that they got from the 485 and not their EADs based on the H4, then they're no longer in H4 status. So there's a distinction between what you're using. If you're just using advanced parole, then that's fine. It doesn't affect your underlying status. But if you're using EAD, then it does.
Got it. So I would again like to repeat the disclaimer here. Please note this show does not provide any legal advice and it is general in nature. It is only for informational purposes. Sakshi TV News or agents are not responsible in any way for your actions. And again, if you want to reach to Attorney Prashanthi Garu for a private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. So Prashanthi, one more question we have got offline from a lot of people is, traveling while the adjustment of status is pending. So what are the implications people have to keep in mind, especially when they have to travel for emergency and still their adjustment of status is pending and no EAD or no advanced parole yet, or sometimes not, they might have even not got receipts because, the receipts are so backlogged. People are still waiting who have filed, I believe, in the October mid or later.
So depending on what basis you're filing your 485, if your basis is family based, then forget it. You cannot travel unless you have an advanced parole approval and you use that advanced parole to travel. If you travel without advanced parole, then you have lost. Your 485 is gone. It gets denied. But if you are filing the 485 based on employment, which is, I guess, what you're asking, then you can travel as long as you have status independent of the 485, as long as you have a visa, which will allow you to come back into the country, you can travel. But remember, if you don't have a visa, then depending on what kind of visa you're trying to get to come back, if you're on an F1, for example, and you're trying to get an F1 visa, then you will not get an F1 visa because you are an intended immigrant and you have the intention to immigrate, and therefore that precludes you from getting an F1 visa. But if you're on a H1, which allows dual intent, then you can come back. You can get a H1 visa and apply for one in the consulate and come back into the country.
We are hearing few news that, do they have to reapply the advanced parole when they leave the country when it's pending, or, that's fine? Any thoughts on that?
Yes, good question. Yeah. So if, first of all, if you leave the country and your advanced parole is pending, you'll most probably get biometrics and you won't be able to go for your biometrics. So practically speaking, no matter what the interpretation of the law is, your advanced parole will most probably get denied and you'll have to refile for advanced parole. But suppose you did the biometrics and then you left the country, then you can always come back, and that should not cancel your advance parole application automatically. Now, I know in the beginning of COVID, there was some discrepancy on this, and some people, some officers were saying that, this invalidates your advance parole application and it gets denied and you have to refile it. But I think there's enough consensus after that. And the law has always been that you can apply for advance parole and leave and do your biometrics and then leave, and your advance parole can even be mailed to you outside the country. And then you can use that to come into the country if needed.
Okay, thanks, Prashanti Garu. We are towards the end of the show. Again, thanks for your time. Thanks, viewers, for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Prashanti.